Every defendant has the absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witness's answer. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I may have excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during the trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was there anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but said the truth about others, you may simply accept the part that you think is true and ignore the rest. The defendant is charged with domestic assault. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant battered Marquita Thompson. A battery is a forceful, violent, or offensive touching of a person or something closely connected with him or her. The touching must have been intended by the defendant, that is, not accidental, and it must have been against Marquita Thompson's will. Second, that at the time, Marquita Thompson was a person with whom the defendant had or previously had a dating relationship. A dating relationship means frequent, intimate association primarily characterized by the expectation of affectional involvement. It does not include a casual relationship or an ordinary fraternization between two individuals in a business or social context. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about February 25, 2024 within the Wayne County Airport. When you go to the jury room, you will be provided with a written copy, your tablet, of the final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberation, please turn off your cell phones or other communication equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on the verdict. In the jury room, you will discuss the case among yourselves, but ultimately, each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. Possible penalties should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to the court officer. It is not proper for you to talk directly with the judge, lawyers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. If you want to look at any or all of the reference documents or exhibits that have been omitted, ask for them. When you go to the jury room, you will be given an electronic copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. The attorneys and I have all approved a jury verdict form that will go in with you to the jury room as well. Now, if you flip back to the little blue index, I'm going to evidence instructions. Thank you. Page 1, circumstantial evidence. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. If you believe that a witness previously made a statement inconsistent with their testimony at this trial, the only purpose for which that earlier statement can be considered by you is in deciding whether the witness testified truthfully in court. The earlier statement is not evidence that what the witness said earlier is true. When the lawyers agree on a statement of facts, these are called stipulated facts. You may regard such stipulated facts as true, but you are not required to do so. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. Back to the index page, folks, for witness instructions. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard testimony from witnesses who are police officers. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witnesses. Gentlemen, are you satisfied with the instructions as given? Thank you, gentlemen. All right, folks, this is my least favorite part of a jury. If you can count, you see there's 7 of you. And I've said a couple times it's 6, 6, 6, 6. So that means one of you get kicked off. And the reason I hate that so much is I've been watching. You guys have all been engaged. I mean, I didn't, Mr. Sharp wasn't sleeping, so I want to kick him off. Everybody was listening and engaged. And I mean, you asked great questions. So I've got 7 little beads in this little box, and they've each got a number on it. One of them is going to be yours. Juror number 6, Ms. Vanderklee. So here's what I'm going to do. You don't get to go in and deliberate. I'm going to send these guys in to do it without you. It'll probably take twice as long without a woman in the room. I'm just probably, that's probably true. But what I'm going to do is I'm going to encourage you to stick around. You don't have to. I'll release you officially right now. But I'm going to encourage you to stick around, because when we're done, when they've given their verdict, when I've shared that with the courtroom, I'm going to go back in there and I do what I call my debrief. You're invited back for that. And I'm also going to ask each of you if you'd be willing to stick around and give some feedback to the attorneys if they want it. Because I've done this with every one of my jury trials since I got on the bench in 1999, and I can't tell you how many times I wish I would have had the chance to do this with my jury trials that I did as an attorney and get some actual feedback. I think it can be very, very effective feedback for a trial attorney to listen to what you folks are thinking after you watch him in action, right? So with that lecture, you can leave. The rest of you might as well all get up, because now Joe's going to take you back in and make you work. This is the time to take your notepads, your tablets. Yeah, questions?
Yeah. What are the charges again? Is it just one?
Just one charge, the charge of domestic violence. Yep. So take your tablets if you want them, take your notepads if you want them, your waters, whatever you want to take back there with you. If you forgot something, we can get it later.
You allowed to have the photos?
Yeah, you can take those back right now. Mr. Leckie, you got them? If you want to see the video again, we'll bring it back out here and play it out here on the big screen and the little ones in front of it. Right. You can just have a seat. Yeah.
Are you breaking from lunch?
I don't think you're breaking for lunch. No, they just want to work. All right.